Good morning, everybody.
Good morning, my lord.
May I have your lordship?
Yes.
My lord,
Any
one
mentioning?
matter at serial number 33, my lord.
Yes.
My lord, in this case, I have been recently engaged. This is a matter under section 148A, but now a judgment has been delivered.
36.
Yes, 33, my lord.
33.
So I am only praying for Passover for the day, my lord. I will inform my counterparts, Mr. Prashant Pallav and Rahul Lamba. This is under section 148A, my lord. There is a judgment of the Honorable Apex Court, wherein all High Court orders have been set aside. So I could not examine that, my lord, judgment.
The main issue which would arise is what happens if the assessment proceedings have been concluded pursuant to that.
Correct, my lord. That is where I need to examine, and there are other judgments of larger bench also of the Supreme Court. So I wanted to get ready to assist your lordship, my lord.
Very well. Mr. Kumar Goria, assisted by Mr. Lukesh Kumar.
Yes, Lukesh Kumar, yes.
Prays for an adjournment. With consent?
My lord, I'll take their consent, my lord. I have not informed them, but I'll take their consent.
From the other side. As prayed for, the matter is passed over for the day. This item 31, Ms. Shivani Jaluka, you are. It's a virus
My
matter.
lord.
It will go with. It's a virus matter.
In item 31, my lord, I'll have to check.
What you have to check? You have filed writ petition challenging section 16.4 and the amendment to rule 61.5. That's a virus matter, so it will go before another bench.
Yes, my lord, it will have to be transferred to the appropriate bench, my lord.
No, but whether you will be appearing in this case, you are now
No, my
AC
lord.
to Union of.
No, my lord, I'll not be appearing in this matter, my lord.
And Mr. Bajrang Kumar, is he also AC to the AJI?
My lord, we'll have to, someone will be engaged, I think, in this matter.
So, what we can do today is to transfer it to another bench because of the virus issue and record your statement that you are recusing and some other person will be engaged.
My lord.
वो 16.4 और वो वाला ऑर्डर करिए, फिर उसमें कोई एक लीडिंग रिट पिटिशन उसका दीजिए और में कहिए our learned counsel for the petitioners submit that since they are now attached to the office of learned ASJI, they would recuse themselves from this case and advise the client to engage, return the brief and advise the client to make some alternative arrangement. Stop. They may do so.
Lord,
एक मिनट, क्या आइटम 30 में क्या है?
पर्सन जो पिटिशनर वो काबिल के पास फाइल नहीं पेमेंट समय चाहते हैं स्टेज का पेमेंट है
Yes, Mr. Neeraj, you wanted to make some.
yes, Lord. Lord, item 23. In that matter, Lord, the matter relating to refund of excise duty in which Mr. Gulati and the learned Advocate General were leading for respective sides. It was heard, my lord, at length, but I hope it will be carried forward today.
No, that is what I also wanted to know. I was sharing with brother also.
My lord.
Today the state had to make the submission, and perhaps from petitioner side also the analysis of parimateria comparative provisions of different acts had to be done.
Yes, madam. So
But
there was
half of the matter was heard when we were sitting in another constitution. So in that case, what is your submission? Mr. Tripathi is also there, and what is the stand of the state?
Yes, I am appearing for the state.
we will be entirely abiding by how your lordship feels about it, my lord. But then it's entirely up to my lords.
No, we can keep it after vacation.
Yes, my lord. In that event, my lord, that will be my lord, the most appropriate thing to my lord, do, subject to my lord, what your lordship feels appropriate. My lord, 15th of June is a Wednesday. If your lordship would be pleased to fix it on that day. 15th, my lord. The week next after the.
Let me see.
My lord, please.
Mr. Mittal, you from
Yes.
state side, your councils, senior council were prepared today, or there was some?
Malaj, I had briefed Mr. Advocate General this morning, Malaj, and he had just Malaj that this was pre.
In fact, my lord,
Very well. So
my lord, we had, my lord, I and Mr. Mittal had spoken about it and shared the feelings with the respective seniors also. We don't know, my lord, what
15th. We'll keep it on 15th June.
we are so obliged, my lord.
Obliged.
So we adjourn on your request. Then, as prayed for by learned counsel for both the parties, let the matter appear on 15th June 2022. Any other small compilation of any other act beyond what had been already submitted, that Customs Act?
My lord, we have submitted, and today I have, Mr. Mittal has sent me yesterday a small chart of comparison of different legislations. My lord.
Yes,
So,
Malaj.
I don't think there is anything else which is to be shared.
No. The legislations, if there are more than the Jharkhand Excise Act and the Customs Act, then you supply those acts also.
Yes.
Malaj, I've supplied the extracts. I'll make a compilation of the entire act as well and send it across.
Which acts?
Malaj, this is the Customs Tariff Act, Excise Act, and the Uttar Pradesh Excise Act, the Karnataka Excise Act, the Bihar and Orissa Act, one more act, Malaj. Rules, excise rules are there, Malaj. The relevant portion has been extracted in my chart. If my lord so wishes, then I will prepare a compilation of the entire act.
If the entire act is not too bulky, then it will be better, because we compare other provisions also, definition clause also, charging provision, and some
Yes.
exemption provisions also, point of sale. So it would be better to give the whole act.
I'll do that, Malaj. I'll do that.
And then if you are doing that much of homework, then please indicate which are the judgments on which acts.
That they have done.
My, yes,
Oh,
Malaj.
that
The
you
That
have
they
chart
have
is
done. In their chart, they have reflected
Yes.
that.
very well. Then exchange it amongst yourself and give it to us at least 2-3 days before the next date.
yes, Malaj.
Very well.
Grateful, my lord.
Grateful, Malaj.
Yes.
My lord, today my lord's camera is not adjusted properly. We are not able to see your lordship's, my lord, completely.
No,
Somehow.
we can see our image, which appears to be fine. Both of us are visible, but Mr. Tripathi, are you also not able to see us together?
Lord, I can see yours, your lordship, but I cannot see Justice Chaudhary's face. As a part
My
of
lord, while my lord, I could see my lord Justice Chaudhary, but I could not see the face of my lord Justice Abhilash Kumar Singh. While your lordships are going to the respective left and right, my lord, then your lordships are not visible. But my lord, we act on the belief.
The quorum is complete. We both are here. That much you can be guaranteed. The rest technology we can't handle because this is beyond our skills.
Right now, none of your lordships are appearing on our screen.
Technician.
Only half of the chairs are not visible.
Very
Probably,
well.
my lord, probably, my lord, Mr. Neeraj has to enlarge his screen, my lord. In fact, he has to pin that.
Then
Visible.
we are not. Very well.
I was only worried because there is another matter in which I'll be appearing.
Why should we worry about that? Let us call the list.
From the daily code list, under the heading for orders with defect, item 1, WPT number 1439 of 2022, Mr. Sumit Gogia for the petition.
Lordship, except the defect number 1, my lord. With respect to synopsis, my lord, we have filed the synopsis, but the line spacing was not good, so defect has been pointed out, my lord. And other defects, we have removed the defects, my lord. Other defects.
Okay. So this is that.
Yes, my lord.
I didn't learn counsel for the petitioner undertakes to file the synopsis with proper line spacing to remove the only defect pointed out by the stamp reporter. By Friday?
Yes, my lord.
By Friday. I will let this matter be placed before a bench of which one of us, Suresh Kumar Singh is on.
Much obliged, my lord.
My appearance for respondent number 3 may kindly.
Mr. Amit Kumar for CGST.
Obliged.
For orders, item 2, WPS number 4944 of 2017, Mr. Ravi Shankar Asman for the petitioner, Mr. Gautam Rakesh.
I am for the petitioner, my lordship. One IE has been filed for substitution, my lordship. IE number 2519 of 2020, my lordship.
Substitution of
petitioner number 2, my lordship.
died on
22/4/2021, my lordship.
Okay. And who are the legal heirs?
His wife, my lordship.
Only one legal heir.
No, my lordship. She is getting pension, my lordship. That's why.
Okay. No. Whether he left behind more legal heirs, you are pleading only one of them? Substituting only one?
Only one, my lordship. Wife, my lordship.
In that case, you should have given an affidavit of the rest of the legal heirs that they are not interested in pursuing the claim. Or you implead at the risk that if they come up.
My lordship, wife is getting pension, my lordship. Family pension, my lordship. A son or daughter are more than 25 years, my lordship. She is not entitled for pension, my lordship.
No, the dispute was about what?
Dispute is about, my lordship, promotional increment, my lordship.
Pay fixation.
Pay fixation, my lordship.
So, service benefits would go to all the legal heirs, though family pension would be agreeable to the widow only.
I will file a IE, my lordship, affidavit on behalf of others, my lordship.
Okay. To substitute deceased petitioner number 2. Petitioner number 2 who died during pendency of this writ petition on 22nd April 2021. IA number
IA number
2519 of 2022 has been preferred by the widow of the petitioner number 2 for getting herself substituted. Learned counsel for the petitioner, learned counsel for the applicant, Mr.
Mukesh Kumar Mehta.
Mukesh Kumar Mehta seeks short time to file an affidavit on behalf of the other legal heirs, being sons or daughters, as to whether they are interested in prosecuting the claim of service benefits and other consequential retirement benefits of the deceased employee, or they are forfeiting their claim in favor of the widow. Stop. In case they choose to pursue the claim, they also need to be substituted. Stop. Learned counsel for the petition, as prayed for by learned counsel for the applicant. Matter is adjourned for 3 weeks.
Yes, my lord.
Listed thereafter on IA number so and so.
My lord, I am appearing on behalf of Union of India.
Shivani Jaruka, AC to ASGI. Let the name of Mr. Prashant Pallav, ASGI, appear in the cause list in place of the erstwhile counsels representing the respondents. Yes.
Item 3, WPS number 52 of 2020, Ms.
I for substitution petition, my lord. Petitioner during the petition of this writ petition, petitioner died on 24th May 2020, my lord, living in 5 legal years, my lord. I have stated at paragraph 4, my lord. And sir, one is the death certificate.
Wakalatnama is on behalf of all the legal heirs.
All the legal years.
Very well. Any objection? Ms. Jaruka, you are appearing.
My lord, I am appearing on behalf of Union of India.
Any objection?
No, my lord.
Third learned counsel for the applicants who are proposed legal heirs of the deceased petitioner, being the 65-year-old person is also his son.
Yes.
Mr. Parthi Kumar Anthony, who is he? At page 4 of your IA, you have named
Page 4, my lord. Discussion of
daughters and three
the.
sons. So how old was the deceased?
This is the petitioner's husband who also died, my lord. Then I have filed the for pensionary benefit. She also died, my lord.
No, these proposed legal heirs
Who died, my
are
lord.
the daughters and 3 sons. One of the son is aged 65 years.
I may be wrong in typing, my lord. That's may be corrected. It may be wrong, my lord, in typing, my lord. I have to verify it, the age.
Or gratuity. So, is there anything wrong in the age?
In the age, my lord. I have to verify the age, my lord. It may be wrong, my lord, in the typing.
Verify the age.
Yes.
Applicants are proposed legal heirs of the deceased petitioner being
Claiming to be their 2 daughters and 3 sons, named at para 4 of IA number so and so. Stop. The petitioner died on 24th May 2020. Stop. However, learned counsel for the applicants, Ms. Mahua Palit, seeks time to take instructions as to the correct description of the age and as to the correct description of the proposed legal heirs, including their age. Stop. Matter is adjourned for 3 weeks. Yes.
Item number 4, first appeal number 151 of 2019, Mr. Deepak Kumar Dubey for the Mr. Ranjit Kumar.
My lord, I am appealing on behalf of appellant, your lordship, in this case.
And I am appealing on behalf of the respondent.
Notice, your lordship, after notice, your lordship, respondent appeared, your lordship. And today is
We can
one limitation petition
and send the
4 days
parties
delay.
back. ठीक है, Mr. Ranjit Kumar.
Yes, your lordship.
We can condone the delay and send the parties for mediation. At
So after vacation, my lord.
आपको थोड़ी जाना है भाई. You need not go to the mediation center. The parties can attend because Jalsa will be working. After 10 days, we will give a date so that you can inform your client about the date. ठीक है.
Lordship.
आइए number 17. The respondent has entered appearance on notice to वकालतनामा. Stop. Item number 17, 24 of 21 has been preferred that combination of delay of 4 days in taking the instant memo of appeal. Mr. Deepak Dubey, mute yourself. Stop. On consideration of the submission of learned counsel for the parties and that the delay is minor, we are inclined to condone it. IA number so and so is allowed. Stop. Para. Learned counsel for the parties agree that an effort for amicable settlement of the matrimonial dispute between the parties Mr. Dubey and Mr. Randir Kumar,
My lord.
Sir.
Age of both the parties appears to be wrong. They are married since 2002. Age is 29 years of the male and 27 years of the female.
Well, the date of birth is given January 1992.
Second paragraph of the impugned judgment, their marriage was solemnized on 18th June 2002.
18 June 2002, your lordship.
So how could they be born only 10 years before? They were blessed with children in 2010.
Yes, Lord. And one girl is at about 11 years, Lord.
सोलह
27 years कैसे लिखा हुआ है?
You find out and give proof of age. ठीक है, प्लेंट में क्या एज दिए हैं? यदि इम्प्यून जजमेंट डिग्री में गलती है तो उसको भी करेक्ट करने के लिए वापस भेजना होगा, और नहीं तो यदि एज शुरू से ही गलत दिया गया है तो भी उसको करेक्ट करने के लिए आपको वहां पर फिर लीव दिया जाएगा, या यहाँ भी हम लोग आइए फाइल करिएगा तो करेक्ट करेंगे.
बेटर होगा हुजूर, यहीं पे आइए हम लोग फाइल करते हैं.
तो प्रूफ ऑफ एज दीजिए कि क्या डेट ऑफ बर्थ का क्या सर्टिफिकेट है।
जी जी, इसको हम लोग आधार कार्ड और मैट्रिक का लगाते हैं।
मैट्रिक से होगा।
मैट्रिक, हाँ, मैट्रिकुलेशन का सर्टिफिकेट लगाते हैं। आइए मैंने
ठीक,
वो अपना लगा
अब
देंगे।
पता करना होगा ना कि मैट्रिक पास है कि नहीं।
लगा देंगे।
तो
Malad, whether she completed board exam or not, Malad.
Mr. Randeep Kumar,
Firstly, we take instruction, Malad.
whatever is the proof of age, it may be a.
मतलब आधार कार्ड तो है मेरे पास हुजूर।
आधार कार्ड is not a proof of age. वो तो अपने मन से
एज Malad. That is.
It's only a proof of.
एक बार इंस्ट्रक्शन ले लेते हैं हुजूर।
ले लीजिए।
हाँ Malad.
Yes, that there is a error in the age of the parties reflected in the impugned judgment and also in the memo of appeal. In the cause title, where the description of the parties is given. Stop. The marriage between the parties as per para 2 of the impugned judgment was solemnized on 18 June 2002. The suit for divorce was filed in 2016, but the age of the parties as reflected from the impugned judgment is 29 and 27 years respectively, which apparently is not correct. Stop. Learned counsel for the parties seek time to verify and file necessary application for correction of the age of the parties with proper with valid documents in proof of the age. As prayed for, matter is adjourned for 3 weeks.
Oblige.
Limitation conduct.
Item 5, first appeal number 264 of 2019, Mr. Nilesh Kumar for the appellant.
My lord, in this case, by order dated 25th 10/2021, notice was issued to the respondent. But till today, cogly shows that no one appeared on behalf of the respondent.
Undelivered registered cover with AD received with the report of postal peon. Addressee went to Dehradun. So you will have to take steps at the present and correct address.
My lord.
In view of the report, in view of the endorsement of the postal peon on the undelivered registered cover within inverted comma, addressee went to Dehradun. Unquote. Learned counsel for the petition appellant. Praise for is allowed 3 weeks time. 1 week time after reopening of summer vacation 2022 to take fresh steps for service of notice upon the respondent at his present and correct address, both in limitation matter and also in the main memo of appeal, for which requisites be filed within the same time.
My lord, kindly permit me to use lordship written copy of the memo, my lord.
Copy of the registered cover may be utilized.
Oblige, my lord.
Fresh service.
Item 6, first appeal number 280 of 2019, Mr. Anurag Kashyap for the appellant.
May I please your lordship in this case? Your lordship. May I, your lordship? May I, lordship?
Yes.
Yes, your lordship. On On the last occasion, the matter has been adjourned on want of instruction that whether appellant is ready to pay rupees 1 lakh as a first installment or not. We have taken the instruction, Lordship. He is ready to pay, Lordship. We need some time to just deposit the same amount, Your Lordship, and roughly about 15-20 days, Your Lordship. In 15-20 days, he will deposit the first installment, Your Lordship.
So today is 11th.
Yes, Your Lordship.
We will fix a date for mediation before Jalsa.
Yes, Your Lordship.
And before the learned mediator Jalsa, your appellant should hand over the demand draft of rupees 1 lakh.
Yes, Your Lordship.
After 20 days.
Yes, Your Lordship. Your Lordship, there is a one difficulty. If he will be posted in some rural area, then he might not be able to come on that day. But I have taken that on which day he has to be posted, so it is up to the contingency of responsibility. Your Lordship, a date may be fixed. If he is not available, then we will file a application.
No. Ask him to take leave to appear on the first date, and thereafter, on subsequent dates, the mediator will fix the date as per convenience of the parties.
Oblige, Your Lordship, oblige.
So ask him to appear on 18th May. Will it be okay?
Yes, Your Lordship. 18th of May, Your Lordship.
Yes.
Yes, Your
Then
Lordship.
counsel for the appellant submits some instructions obtained pursuant to the previous order dated 4th May 2022 that the appellant is ready and willing to pay part of the arrears of maintenance, that is rupees 1 lakh, as first installment within a period of 20 days to show his bona fide. Stop. Learned counsel for the parties agree that an effort for amicable settlement of their matrimonial dispute may be made once again at Jhalsa. Stop. Parties are ready and willing to appear physically at Jhalsa. Stop. As such, let the parties appear before the learned member secretary Jhalsa on 28th May 2022 at 10:30 am. Learned member secretary can be approached on the following numbers as well. Stop. The appellant will, on their appearance, the parties should be referred for mediation. Stop. No, the matter would be placed before the learned mediator. Also, appellant pay the sum of rupees 1 lakh as first installment of the arrears of maintenance through demand draft to the respondent in the presence of learned mediator Jhalsa on 28th May 2022. Stop. Parties are expected to cooperate in the proceedings with an open mind and attend each of the sittings. This appellant shall pay a sum of rupees 1,500 per day towards travelling and incidental cost to the respondent on each date she appears before the learned mediator, in the presence of, participates in the mediation proceedings, in the presence of learned mediator Jalsa. Stop. If the parties are able to arrive at an amicable settlement, terms and conditions thereof be reduced in writing under their joint signature and be submitted along with the report. Stop. Subsequent dates, learned mediator may endeavor to post the hold sittings, subsequent sittings as per convenience of both the parties.
Okay.
Stop. Let the matter appear in the week of 11th July 2022 along with the report.
Your Lordship, one small prayer, Lordship, in this case. 5,000 is directed to be deducted from the salary of the appellant, Your Lordship. If Your Lordship possible, kindly stay. If he will pay the rupees 1 lakh rupees as a first installment, Your Lordship, subject to the payment.
on proof of, नहीं, आपको 5,000 जो है वो तो बाकी एरियर देना ही होगा, वो आपका 1 लाख जो है वो डिडक्ट हो जाएगा एरियर से once you prove show the
Yes,
proof
Your Lordship,
before
but
the
the learned court will has directed the district education officer to deduct the 5,000 from the salary of the appellant, Your Lordship. Your Lordship, that's it. If it's subject to the, if he will deposit the, then the stay will be in the effect, Your Lordship.
स्टे तो नहीं होगा, ये तो आपने 3,90,000 नहीं दिया है और वाइफ को उसे मेंटेनेंस नहीं मिला, इसीलिए आपने चाहा कि दोबारा मेडिएशन हो जाए।
Yes, Your Lordship.
तो उसकी बोनाफाइड को देखने के लिए आपको 1 लाख एज ए
Okay, Lordship. On I will pray this prayer on next date of this, Lordship.
होने दीजिए।
Yes, sir. Oblige, Your Lordship.
Oblige, Lord.
Item 8, first appeal number 3, sorry. Item 7, first appeal number 311 of 2019. Mr. Roteshwar Rai.
Your Lordship, in the last order dated 8th of October 2020, it was directed by the Honorable Court to serve the notice to the respondents, but till this date, the notices still not have been served, Your Lordship.
In that case, through all the 3 modes, the service has remained unaffected, and there are endorsement of the postal pune also on some of the undelivered registered cover at all the 3 addresses. So then you will have to take steps for substituted service.
Take steps for what, Your Lordship?
Substituted service through paper publication.
Yes,
or
Your Lordship.
otherwise, if you can trace the real address, present address of the respondent, which seems to be unlikely, since how long they are separated?
Your Lordship, it has been 2-3 years, Your Lordship. 2007.
The marriage was of April 2015. They are separated since past 3 years. Is it not possible for your appellant to find out the present address of the respondent husband?
I will get the instruction from the petitioner, Your Lordship, and get the correct address or the updated address.
Is there any criminal case pending between the parties?
Your Lordship,
Or any maintenance
no, Your
case?
Lordship. No, Your Lordship.
You better seek instruction, because otherwise the cost of paper publication would be substantial upon the appellant, who is a lady. And if there are any cases between them, then notices can be served through the counsel of the respondent, representing him in the concerned court.
Yes, Your Lordship.
You are with the office of Mr. Rohit Roy.
Yes, Your Lordship.
Inspect the records also and see, because the office note is quite elaborate in respect of the report of service report to all 3 modes.
Yes, Your Lordship.
Whether the notice that was served on the party by registered post Has it been returned or not? If it has not been returned, then doing service can be considered.
That we are done.
As far as notice issued through registered covered with AD, the same has not been received. When was this registered post, sent by registered post? देखिए तो,
24th of November, Your Lordship.
it is more than 3 months.
Yes, Your Lordship.
The PC does not receive. Once it is not received, once the registered post is not returned, then there is a deemed service. कहाँ पर है देखिए?
Speed post वाले में consignment details not found. Yeah. हर एड्रेस पे ना 2 मोड से गया है. Speed post से registered cover से.
जब रजिस्टर्ड पोस्ट वापस नहीं आया है तो डीम्ड सर्विस हो जाएगा.
उसको नहीं, उसको वैलिडिटी में नहीं दे रहे. Ultimately, उसका पेमेंट सिंसियर नहीं होगा तो ये contest unconsided. The maximum effort is made to ensure service. ठीक है. वाला कहाँ इसका कि नहीं है.
रिटर्न कर देता है जहाँ नहीं होता, लेकिन जहाँ रिटर्न नहीं होता तो जान की दे आर इरेटिंग. So why to give them advantage of that?
उसका स्पीड पोस्ट वाले में लिखा हुआ कंसर्निंग डिटेल्स नॉट फाउंड, मतलब जो एड्रेस है उसको नहीं ट्रैकिंग द फुल स्पीड पोस्ट Notice has not been effected at any of the addresses as per the service report. As per the office note containing the service report effected on the respondent. Staff Learned Counsel for the appellant seeks time to ascertain the present and correct address of the respondent. Let the matter is adjourned to be listed in the week of 13th June 2022.
Obliged, Your Lordship.
Item 8, first appeal number 323 of 2019, Mr. Awnis Ranjan Mishra, for that.
May I please the lordships? IA is minutes for condonation of delay of 74 days in preparing present memo of appeal minutes.
Divorce has been granted.
Yes, minutes. Memo of appeal is against the judgment and decree passed by learned Principal Judge, Family Court at Bokaro, by which he has been pleased to allow application filed by respondent, petitioner there at learned court below, under section 13(1) of Hindu Marriage Act minutes, without giving proper opportunity and without hearing present appellant minutes.
Issue notice on the both the addresses of the respondent under ordinary process and speed post, for which requisites be filed within 1 week.
Yes, minutes. I'll file.
Within 1 week. Peremptory.
Obliged, much obliged.
both in limitation matter, IA number so and so, and also on the main number.
Item 9, first appeal number 19 of 2020, Mr. Shankar Singh, for the
Yes, my lordship, I am appearing on behalf of the appellant, my lordship. The present IA application filed under Order 5 Rule 20 of Code of Civil Procedure, my lordship, for allowing to take steps for substituted service of notice by publishing the notice in Prabhat Khabar, my lordship. Earlier to this, my lordship, the appellant, wide order dated 7/12/2020, passed by this honorable court, take a step for service of notice upon the sole respondent, which was taken within the time, and that is answered with endorsement addressee left without information. And again, my lordship, on 15/9/2020, my lordship, appellant also compliance of the order by this honorable court sent notice, but same was unaffected, undelivered registered cover with AD and undelivered speed post has been returned with same endorsement addressee left without information, my lordship.
IA number 3881 of 2022 has been preferred by the appellant seeking substituted service through paper publication on the respondent, as despite steps taken on two occasions, including on the present and correct address of the respondent, notice could not be effected with the same endorsement of the postal peon that the addressee has left without information. Stop. Having regard to the prayer made by the appellant and the reasons shown, let substituted service of notice be effected in terms of Order 5 Rule 20 on the respondent at the last known address where he resided. Through paper publication in two local daily newspaper having Prabhat Khabar and Hindustan, having wide circulation in the area in which the appellant, a respondent, last resided. Stop. Let requisites for service of notice through such mode be filed in the registry by. Will you be able to file it by Friday or after vacation?
After vacation, my lordship.
By 10th of June 2022, office to issue draft of service upon learned counsel for the appellant by 17th of June 2022. Stop. Upon service of notice to the aforesaid mode, a supplementary affidavit be filed with proof of service within 3 weeks thereafter.
Obliged.
Disposed of. Both limitations.
item number 10, first appeal number 31 of 2020, Mr. Vikas Kumar, for the appellant.
Milords, in compliance of Milords order dated 17th of December 20, Milords had filed the requisites, Milords, on 18th itself, 18th of December.
The notice has remained unserved. Notice has remained unserved with the endorsement left RTS Tracking report shows consignment details not found. So take steps at the present and correct address.
Milords.
Since notice could not be effected upon the since the undelivered registered cover with AD has been received with endorsement of postal peon that left RTS within inverted comma, and the tracking report of speed post also shows consignment details not found, then counsel for the appellant seeks time to take fresh steps for service of notice upon this respondent on her present and correct address, for which 4 weeks time is allowed.
Milords.
Requisites be filed within the same time.
Obliged, Milords.
Under ordinary process and registered speed post.
Item 11, first appeal number 23 of 2011, Mr. Rohit Agarwal for the
Lordship, in this case, on last occasion, notice was issued to the respondent, Lordship.
Same position, take fresh steps.
Lordship, I will take the fresh steps.
Insufficient. In view of the report of the postal bureau on the undelivered registered cover within quotes addressee left, and also the service report under ordinary process within quote insufficient address, then counsel for the appellant seeks and is allowed 4 weeks time to take steps for service of notice upon the present and correct address of the respondent, both under ordinary process and speed post, for which requisites be also filed within the same time.
Obliged, Lordship.
Item 12, LP number 341 of 2021, Mr. Rahul Dev for the appellant, Mr. Ajit Sinha.
Hello. In this matter, I am appearing for the appellant, and I have given, pursuant to my Lord's instruction, I have already given the compilation, the convenient compilation. And if your Lordship has it, compilation.
Mr. Biswajit, if you can wait for some time, we might just take up the matters which are small matters which may take few minutes.
Milord, may I just make one little submission? Milord, I am entering my appearance today, Milord, on behalf of the Reserve Bank of India, respondent number 2. So, Milord, I don't know, Milord, whether all the materials are there with me. Some compilation has been given to me. Milord, we have to check with whatever Mr. Biswajit has filed so far. And I would request for a small opportunity.
Well, today is actually only posted for interim relief only, and to which it is not query the RBI. This is in pursuance to a Lordship's last order, 28th of March 2022, where a limited query was posed, Lords, that why the interim order in the...
We'll come back to your case.
Let's
just go through the smaller matters.
For admission, item 13, TA number 25 of 2019, along with item number 14 and 15, Mr. Rahul Lamba for the appellant.
Lordship, I am appearing on behalf of the association.
Wait, please, Manoj.
Malaj, I had sent the proposed questions of law, Malaj, yesterday.
Yes.
If my lords have it, Malaj. I had sent it to the respondents also, Malaj.
In all the three appeals?
In all the three appeals, Malaj.
Okay. So in TA 25 and 37,
Malaj,
TA
the
20,
question.
38 are identical.
Malaj, identical except question number 3, Malaj.
Very well.
The findings, Malaj.
Whether in the fraction of the amount in the this judgment of rotor controls applies even in 37 of 2019.
Yes, Malaj, because even there were certain provisions not of warranty expenses, but expenses in the nature of provisions which were involved, Malaj. So, Malaj, Rotork judgment, Malaj, considers how the expenses of provisions can be allowed, Malaj. So that judgment will apply in these cases also, Malaj. If my lords can have para 22 of this judgment, my lords, at page 292.
Yes.
Malaj, the principles have been laid down, Malaj, in this judgment that how generally an expense in the nature of provision can be allowed. Though, Malaj, in that case, the provision was of warranty expenses. But general propositions have been laid down, Malaj, how an expense in the nature of provision can be allowed.
Very well. Let's say the TA 25 of 2019, this appeal shall be heard on the following substantial questions of law. ये देखिए 1, 2, 3, 4. The TA 38 of 2019 में भी लिखिए. This appeal shall be heard on the following substantial questions of law. और TA 37 में लिखिए 1, उसके बाद 2 में लिखिए whether in the facts and circumstances of the case the principles, the ratio laid down by the apex court in the case of Rotork so and so 2009 13 SCC 283 would apply to the case of the respondent SSE so far as his claim of expenditure on within quotes provision for leave travel assistance unquote comma quote provision for liquidated damages unquote and miscellaneous provision within quotes be claimed towards business income of the respondent under the Income Tax Act 1961. पढ़िए तो
Whether in the fact or circumstances of the case, the issue laid down by the tax court in the case of 2009 13 issue 283 would apply to the case of the respondent assessee so far as his claim of expenditure on
entitlement of expenditure towards business income.
each claim
Entitlement of expenditure towards business income.
has been found in the common provision of travel assistance and
उसको ऐसे लिखे claim of entitlement of expenditure towards business income. उसके बाद ये तीनों लिखिए provision. फिर से पढ़िए तो
the issue laid down by the tax court in the case of 2009 13 basis 283 would apply to the case of the respondent assessee so far as his claim of entitlement of expenditure towards business.
उसके बाद
provision
under provision of so and so, provision of so and so, provision of so and so is concerned under the Income Tax Act 1961. So this reframing, Mr. Lamba and Mr. Anupam Anand, this takes care of.
Yes, yes, ma'am.
Three.
Mas, question number 3 is also different, Malaj.
Whether in the fact the right is correct in what three will remain the same. 4 also same.
Lordship, may I make one prayer?
Call for the lower court records from ITAT तीनों अपील में जो है ना from so and so so and so. Yes, Mr. Anupam.
Your Lordship has already taken care of my prayer, Malaj. The LCR has been solved.
Much obliged, Malaj.
Very good.
Item number 16, first appeal number 271 of 2019, Mr. Anup Kumar Agarwal of the appellant.
May I please, Your Lordship, appearing for petition in this matter, Lordship. This first appeal is arising from an Lordship judgment and decree passed by the Family Court, Ranchi, Lordship, whereby an application filed by the respondent for restitution of conjugal right has been allowed, Lordship. Notice is required to be issued to the opposite parties in this matter.
What are the new documents which you want to bring on record?
Lordship, there are certain subsequent development, Lordship, which took place after passing of this decree, Lordship. The respondents has issued several legal notices and the notice to the petitioner, Lordship, saying that they are proceeding towards the Lordship dissolution of marriage and they have served a notice for divorce, Lordship. Therefore, I have filed this application for bringing all those documents by which a notice has been served upon.
So let them appear in the appeal. Once they appear, then the IA upon the respondent.
Yes, yes, ma'am.
Issue notice on the respondent under. At both the addresses. Under ordinary process, registered cover and speed post, for which requisites be filed within 1 week after the opening of summer vacation 2022, failing which the appeal shall stand dismissed without further reference to the bench. 18-19 जरा पहले कॉल कर लीजिए।
Item 18, appeal number 59 of 2020. Mr. Satish Kumar for the appellant, Mr. Pratish Lala for the respondent.
Well, in this case, my lord, I am appearing on behalf of the my lord, as appellant, my lord. So the wife, my lord, of the respondent.
So respondent is appearing, Mr. Lala.
Yes, my lord. Yes, my lord. He is appearing. My lord says, if my lord, the respondent is agree, my lord, the send the matter to the Jhalsa, my lord, for mediation.
Mr. Deepak Sahu, you are appearing for respondent. Unmute.
Yes, my lord. I am appearing on behalf of respondent, my lord.
So let the parties go for mediation at Jhalsa.
Yes, my lord.
Respondent has entered appearance through Wakalatnama upon notice. When counsel for both the parties agree that an effort for amicable settlement of the matrimonial dispute can be made through mediation at Jhalsa at the appellate stage also. So parties are ready and willing to attend to the proceedings of attend the mediation proceedings physically at Jhalsa. Stop. In that view of the matter, let the parties appear before the learned member secretary Jhalsa on 21st May 2022 at 10:30 am. Stop. Learned member secretary Jhalsa can also be approached on the following numbers. On their appearance, parties the matter be placed before the learned mediator Jhalsa. Stop. Appellant shall pay a sum of rupees.
And the appellant is the wife, my lord.
Sorry, the respondent shall pay a sum of rupees 1,250 to the respondent. No, 1,500 to the respondent towards travelling and incidental
To the
expenses.
petitioner, my lord, to the appellant, my lord, sir.
To the appellant towards travelling and incidental expenses. On each date, on each date, the appellant participates in the mediation proceeding, in the presence of learned mediator Jhalsa. Stop. Parties are expected to cooperate in the proceedings with an open mind and attend each of the sittings. If the parties are able to arrive at an amicable settlement, terms and conditions thereof be reduced in writing under their joint signature and be submitted along with the report 4 weeks thereafter. Matter be placed in the week of 4th July 2022 along with the report.
Item 19, first appeal number 62 of 2020.
May I please?
Mr. Mukesh Yadilal.
May I please? In this case, the petitioner challenged the order passed by the Principal Judge Family Court by which the petitioner under Section 281 of the Mohammedan Act was ejected. Constitution.
Mr. Shailesh, you are appearing for the wife.
Yes, sir.
So let both of them go to mediation.
मीडिएशन हुआ था जो धनबाद में, लेकिन वो फेल कर गया और हम हमेशा तैयार रहते हैं उनको रखने के लिए, लेकिन
तो मेडिएशन एक ही बार कोई जरूरी नहीं ना, हर स्टेज में हो सकता है।
ठीक है, ठीक है।
मैट्रिमोनियल डिस्प्यूट मेडिएशन से रिजॉल्व हो जाए
हाँ तो ज्यादा अच्छा है जी।
बट उनका
ये So you have heard the previous order, डेट फिक्स कर देते हैं वही 21 मई का।
ठीक है, 21 मई को। हाँ,
और ट्रैवलिंग एंड इंसिडेंटल एक्सपेंसेस 1250।
ठीक है, ठीक है।
Mr. Shailesh,
I pray for one thing. If it would be proper for going for mediation at Dhanbad itself,
नो नो, वो जो है ना वो
बाद में तो एक बार हो चुका है।
जी आपका ठीक है, आपका आदेश ये रांची चूंकि हम लोग छुट्टी का समय हम लोग
डिफरेंट एनवायरमेंट, डिफरेंट प्लेस।
जी बिल्कुल, जी बिल्कुल, जी बिल्कुल, जी बिल्कुल, जी बिल्कुल।
So 24th May 2022, 1250 expenses, or week of 4th July along with the report.
झालसा में 21 मई को ना 21
हाँ,
मई
21 में 10:30 बजे।
ठीक है।
Item 20. Year number 11 of 2021.
सभी का application का हो जाता है, तुरंत अपना नेटवर्क में आ जाता है। इसमें तो आप yes.
Item
Yes, what about this, Mr. Lamba?
Malaj, I've received the instruction, Malaj. This matter is falling under exception, Malaj, because the assessment was done based on a revenue audit objection. And Malaj, revenue audit objection was accepted, and therefore, Malaj, it is falling under exception, Malaj. I had emailed these instruction, Malaj. Apologies, Malaj, that the instructions are not very legible. In fact, the copy which I have got also is not very legible.
So the appeal was partly allowed.
By the commissioner appeal, Malaj. Commissioner appeal partly allowed the appeal, and thereafter, Malaj, the matter travelled to ITAT by both the assessee as well as the department, Malaj. And department lost in both the appeals, Malaj. That is the appeal preferred by the assessee as well as the appeal preferred by the department, Malaj.
So the ITAT, so page 30 is the, which says SSC's appeal is partly allowed.
Manoj, yes, Manoj. In fact, ITAT has also allowed assessee's appeal partly. In fact, Manoj, the commissioner appeal had also allowed his appeal partly. So the part which was denied or as in dismissed by the commissioner appeal was challenged by the assessee before the ITAT.
Your Lordships, I appear on behalf of the respondent. I would just like to apprise Your Lordship with one fact of this matter case, Your Lordship. The Honorable ITAT had passed two different orders, Your Lordship, in this matter. One was against the SSC's appeal and one was against the revenue's appeal, Your Lordship. Against both these appeals, different tax appeals have been filed in the High Court. And the tax appeal which was filed against the revenue appeal has already been dismissed by order dated 7th March 22 on tax effect, Your Lordship.
Malaj, in that matter, Malaj, the department is going to file a CMP, Malaj, for restoration because when that matter was taken up, Malaj, the department inadvertently did not find out that this was because of a revenue audit objection, which is an exception. So, Malaj, though the monetary limit is less, but it fell under an exception.
How can the CMP be? It is not for an ordinary correction.
Malaj, for restoration, Malaj, my learned friend Miss Amrita Sinha is doing that matter. Malaj, she is handling that matter, Malaj. So, Malaj, because inadvertently.
No. So therefore, in this case, why don't you bring on record the other passed by the order passed by the ITAT against you? in your appeal?
No, because we are not challenging that order here, my lords. We are only
Here you are
challenging.
not challenging, but to make the records complete, because that order was under challenge in the
Other tax appeal.
Which has been dismissed.
My lords.
You should have brought it to our notice.
Your Lordship, just one more request.
We'll file that order.
Your Lordship, notice has not been issued in this case, Your Lordship. We had filed a wakalatnama on the previous date, but that same could not be admitted because the notice has not been issued. So, if the necessary direction for the issue of notice may kindly be given, Your Lordship.
Our order of the last date was sufficient. Still, the wakalatnama has not been accepted.
Yes, Your Lordship.
But it is perhaps because notices have not been issued, my lords. That is the difficulty, my lords.
In the office report of 30th April says no any wakalatnama has been filed as yet as per computer inquiry. That means
Your
it has
Lordship,
not
we had filed the wakalatnama on 8th of March. Actually, it was dropped in the Dropbox that time due to the COVID, Your Lordship. So, probably we will file it again, Your Lordship, within next 2 days.
Okay. Notice is waived by Mr. Devesh Poddar. Issue notice upon the respondent. Stop. Notice is waived by Mr. Devesh Poddar, Learned Counsel, since he has already, as he had appeared on the previous date, 7th March 2022, and undertaken to file wakalatnama. Stop. Our Learned Counsel, our Mr. Poddar submits that the wakalatnama has not been formally accepted, though it was dropped in the Dropbox on 8th March 2022. Stop. He would again file the wakalatnama, fresh wakalatnama, if need be. Stop. Let fresh wakalatnama be filed by Friday. Office shall accept the wakalatnama of the respondent. Stop. Let his name be reflected in the cause list. Henceforth, लिखा हुआ था पिछले order. Stop. Learned Counsel for the appellant, Mr. Rahul Lamba, undertakes to file the order passed by the ITAT in the revenue appeal, against which tax appeal number?
Your Lordship, tax appeal number 34 of 2019.
34 of 2019 arose. Stop. Learned Counsel for the respondent informs that tax appeal number 34 of 2019 was dismissed by this court on 7th March.
Yes, Your Lordship.
22, as the tax effect of the disputed amount was less than the monetary limit prescribed by the CBDT circular. That was the reason?
Yes, Your Lordships.
Stop. Matter be listed in the second week after the opening of summer vacation.
Malad, my submission that though it is less than monetary limit, but it falls under exception, may also be taken into court.
No. Why should we take that? Because there is nothing to say that today.
Malad, I've sent the instructions, Malad.
Instructions refer to the present appeal or the one which has been...
The present appeal, Malad. The instruction dated 10/5/2022, Malad, 10th May.
Very well. Iska likhiye. Learned Counsel for the appellant. I thought you were referring to the appeal which has been dismissed.
No, Malad, in this appeal, Malad.
Learned Counsel for the appellant, ऊपर में यहाँ लिख रहे थे उनका submission वहाँ लिखिए. Submits on the basis of written instructions furnished by the Office of Principal CIT, Dhanbad, contained in letter dated 10th May 2022, that the present appeal falls within the exception clause 10C, within bracket small c, of CBDT Circular number 3 of 2018, being a case where objection has been raised by the revenue audit. Let the instruction be also kept on record.
Much obliged.
Item 21, LPA number 13 of 2021, Mr. Sisid Suman for the appellant. Mr. Tarun Kumar Mathur, Mr. Ashok Kumar.
This case, Your Lordship, on last occasion notices were issued, and for respondent number 4, Mr. Mukesh Kumar had appeared.
Your Lordships, in this case, on behalf of respondent number 4, Your Lordship, counsel for respondent number 4 is not well, Your Lordships. Mr. Mukesh Kumar has sent an email also, Your Lordships, for adjournment. He is not well, Your Lordships.
So, from 1 to 3, Mr. Ashok Kumar Yadav appears.
Yes, my lord, I am appearing for 1, 2, 3, my lord.
Yes. And for 4 and 5, Mr. Mukesh Kumar appears.
Only for 4, Your Lordships.
Only
Mr.
for
Mukesh Kumar
4.
is appearing.
4, what about 5?
Mr. Rohit Roy appears on behalf of respondent number 5.
So, all of you consent to the adjournment request made by Mr. Mukesh Kumar?
Yes, my lord. Yes. Let it be after vacation, my lord.
Request for adjournment has been made on behalf of the council for the number 4, Mr. Mukesh Kumar, as is not well. Stop. Email was also circulated. An email
Yes, Your Lordship, email was also circulated.
the parties who consent to stop. The council for the other parties do not have any objection to the request for adjournment. Accordingly, matter be listed after summer vacation 2022.
Your Lordship, any date may be fixed.
In the week of 16th June 2022. 16th June. Yes.
Item number 22, LP number 63 of 2021, Mr. Ashok Kumar Yadav for the appellant, Mr. Amit Kumar Barma for the respondent.
My lord, in this case, I am appearing for the appellant, my lord. I am praying for an adjournment, my lord. My lord, let it be after vacation, my lord. My lord, it has come after assignment to your lordships, my lord, from bench number 1, my lord, AV number 1, my lord. My lord, today I am not ready, my lord, therefore I am praying for adjournment.
So this is the state appeal.
Yes,
because writ petition was allowed.
Yes, my lord.
Punishment order. 20%.
Punishment order has been set aside.
As prayed for by Land Council for the appellant state, Mr. Ashok Kumar Yadav, the matter is adjourned to be listed after summer vacation 2000.
Item number 24, WPT number 4027 of 2021, Mr. Manav for the petitioner, Mr. Ashok Kumar Yadav for the.
Yes, my lord, I am appearing in this case. My lord, this is an application for refund of the amount which was realized by the respondent by attaching my bank account during the pendency of the writ application which were filed earlier by us before this honorable court, my lord. And they have filed counter affidavit in which they have raised an objection that since Supreme Court has not stated refund of the amount, therefore petitioner is not entitled to get refund of that amount. My lord, list of dates I have given in my rejoinder.
Mr. Poddar, then please wait. Let us first go through the smaller matters.
Okay.
There are two more left.
Okay.
Item 25, first appeal number 14 of 2022. Mr. Patil Lal for the appeal.
May it please the Lord. This is the first appeal instituted by the husband against the judgment whereby my prayer for divorce was dismissed by learned court below. I am husband. I have filed a case for divorce against my wife that has been dismissed.
Issue notice on the respondent under ordinary process, registered cover and speed post, for which requisites to be filed within 1 week after the opening of summons application 2022, failing which the appeal shall stand dismissed without further.
Highly obliged.
Item 26, WPT number 985 of 2022, Mr. Nitin Kumar Prasadi for the petitioner, Mr. Dahul Sabu for the response.
May it please the Lordship.
Mr. Kurme, this will take some time, so please wait.
My lord, my lord.
We will sequentially come in the main matter
My lord.
after the
My lord, my lord.
Item 27, WPT number 1239 of 2022, Mr. Deepak Kumar Sinha for the petitioner. Mr. P.S. Pati for
Yes,
the...
my lord, there are three matters, my lord, 27, 28 and 29, my lord. All
all
are
have
similar in nature, my lord.
same relief.
Yes, my lord. Yes, my lord. And we have challenged these cases are fully covered by the ANCAS judgment, my lord, which has been passed by my lord, dated 8/6/10/2021, wherein the so-called notice DRC 1 has been challenged, my lord. And exactly the same thing is here also, my lord. Kindly, my lord, may see annexure 2 at page 30, my lord. Similar so-called notice in format, in just the verbatim of the section 73, my lord.
Yes, Mr. Pati and Mr. Mittal.
Well, this is covered by Maladi's judgment on NPS.
You file an affidavit, counter affidavit?
Yes, your lordship. 3 weeks time will be given. For filing a
Well, we can file a counter affidavit, Malad, but it may be an exercise in futility. But we file it, Malad. That
you are being very fair, but whether your clients have instructed you specifically to say to that effect?
Malad, I had spoken with the clients yesterday, Malad, and they are aware, Malad, because these notices have been issued by a particular officer at a particular point of time who is now retired. Malad. Yes, Malad.
Same officer, but
yes,
see.
Malad. Yes, Malad.
NCAS judgment you have annexed?
It had not been annexed, my lord, because I was it has not been seen, my lord. Para 17.
So, you counsel for respondents would be filing affidavit or what? We will record your concession that you do not dispute.
Malad, I'll file a counter, Malad. Let it be on record, Malad. I'll file a counter.
That would be better because these are revenue matters.
Yes, Malad. Yes,
Either let them say that it is covered by NCAS and same notice format, same issue?
Yes, my lords, I've spoken to them, my lords. I've even conveyed that this is covered. This is the covered matter, but their difficulty is in withdrawing these notices, my lords, and that is why, my lords, let there be a counter, my lords, and a similar order like that of NKS can be asked, my lords, whenever it is listed next.
Very well.
Worship 3 weeks time maybe.
So you will be able to file within 3 weeks positively.
Yes, my lords.
Yes,
All the three can be tagged to each other or keep it separate?
No, my lord, similar matters, similar notices are there, my lord. Only dates are changed, my lord.
Same circle, Gudda.
Same circle. Has been issued by same department, my lord.
Let WPT 1261 of 2022 and WPT 1263 of 2022 be tagged along with the present writ petition, as common issues are involved as per Learned Counsel for the parties. Stop. Learned Counsel for the respondent state, Mrs. Ranjana Mukherjee, AC to Mr.
I'm representing. I'm
Oh,
representing
acha.
Mr. K.S. Pati because he is not here. I'm the state.
C.S. Pati and Mr. Salona Mittal, AC to GA1. Pray for and allow 3 weeks time to file counter affidavit. Informally, the Learned Counsel for the petitioner submits that the issues raised in these writ petitions is covered by the judgment rendered by this court in the case of NCAS, Mrs. NCAS Services Private Limited versus the state of Jharkhand and others, dated 6th of October 2021, rendered in WPT number 2444 section 73. All these notices are under section.
It's 73, my lord.
My lords, but interestingly, my lords, penalty of 100% has been levied.
Yes, my lord. Why you saying 73 notice, 74 penalty has been imposed.
It is submitted that though the purported notices are under section 73(1) of the JGST Act, but the penalty of 100% has been imposed, contrary to the provision under section 72.
Plus some interim protection may be given, my lord.
Interim protection board. No DRC 13 has been.
Yes, my lords.
List the case in the on 16th June 2022, so that petitioner, if so advised, may file reply thereto in the meantime.
In the meantime, my lord.
No, not now.
No, because they are nothing to address.
They are aware about their own folly, so we don't think they would
Therefore,
precipitate the
some
matter.
protection may be given because they are under protection, my lord. Some protection till next date, till next date of hearing.
No, my lords, I can inform the concerned officer, my lords, they are aware of it. Yes, my lord.
Item 30, WPT number 1580 of 22, Mr. Deepak Kumar Jaiswal, in person of petitioner, Mr. Rahul for the
Petitioner in person has made a request for adjournment through email. Mr. Rahul Lamba appears for the respondent department. Mr. Lamba, what kind of a prayer is this? Not very.
Well, it is incomprehensible.
Clear.
Well, it is incomprehensible, Malad. I have read it thrice yesterday night, but I couldn't understand what is he asking, Malad.
And doesn't appear as to how he is concerned with the leave encashment issue.
I thought, Malad, initially I thought he is an employer, an officer of income tax department. Instead of filing a WPT, he has filed a WPS, he has filed a WPT. But somewhere I realized he is not an officer.
No, he appears to be what is his locus to seek a specific relief in respect of leave encashment computation and exemptions under IT Act is not comprehensible. As per the request of the petitioner in person, let the matter appear on 6th June 2022.
Much obliged.
Item number 32, WPT number 1821 of 2022, Mr. Ritesh Kumar Gupta for the petitioner, Mr. P.S. Pati, Mr. Amit Kumar for the respondent.
May it please your lordship. Your lordship, these are matters which are related to the levy of GST on payment of royalty, your lordship. And civil
Have you
orders have...
sent that short order?
Yes, your lordship, we have sent both the orders, your lordship. The detailed interim order as well as the short order.
This is only GST on royalty.
Yes, your lordship.
इसका ये शॉर्ट ऑर्डर जो है 27 अप्रैल का इसका पैरा 2 who is appearing, Mr. Pati and Mr. Amit Kumar for the state and
GST lordship I am appearing.
For state, yes, please.
Very good. So para 3 also common, 4 also common. And 5 also same. It is tagged with WPT 432 of 21. And same in 3 weeks for the petitioner to file it April 2022.
Much obliged, lordship.
Oblige you.
Item number 34, WPT number 1858 of 2022, Mr. Nidhi Kumar Prasadi for the petitioner, Mr. Rao Lamar for the respondent.
Look, this is a fresh filing matter. The challenge is to the notices and not on the email. And based upon them, the final order has been passed. So, going by the judgment of commercial steel, my right in terms of section 148A has been completely taken away, and tax liability has been fastened upon me.
Yes.
When it's 148A, an inquiry would be carried out, my objections would be taken care of, and thereafter, if not satisfied, then a notice under order under 148AD would be passed, and then 148 proceedings would be initiated. Now, in this case, the notices were floated. Yes, Manoj?
What would be the effect of the judgment of the apex court passed in that commercial?
That would not come in the way in this case, Manoj. That would not be applicable in this case. Because this is
what
a different
is the stage of the present proceeding? They are going on with the assessment.
They have already concluded, Manoj. They have already passed an order under 148 AD.
So, no. The preliminary inquiry as contemplated under section 1, amended section 148 has been undertaken, and you say that there was no valid service upon you.
Absolutely, Manoj. Absolutely. Because
But
the service was on
thereafter, what is the stage of the assessment?
Manoj, 148 notice has been issued upon me. Because Manoj, what would happen is, once they decide to initiate a proceeding, they would issue me a notice under 148AB. When I file my objection,
where are the new? Have you enclosed the new amended sections?
Yes, Manoj, I have annexed it. That starts from page 41, Manoj. The relevant would be at page 140, at page 43.
Yes.
Page 44 would be relevant where 148A has been introduced, Manoj.
Mr. Lamba, your those matters are coming tomorrow.
Yes, my lords. Yes, my lords.
How many matters are there?
My lords, tomorrow, my lords, there are 7 matters, but my lords, there are other different isolated matters also. My lords, tomorrow the matters which are coming up is a batch. And my lords, there are some isolated matters also, my lords.
Isolated matters where
But this matter does not relate to.
no, they were taken up earlier and some interim order was passed.
Yes,
or
yes.
they are
No.
yet to come.
My lords, they are yet to come, my lords.
Okay.
My lords, in
So
the matters
whatever
in
be the
which
fate of the batch cases, that will apply to the other cases also.
Indeed,
Yes.
my lords.
Of pre-31st March
Well.
2020.
Yes, yes.
Yes, so here the issue which the petitioner seeks to raise is that in the absence of a proper notice in terms of section 282,
Read with Rule 127, my lords.
any further initiation of proceedings for reassessment under the amended section 148A would be bad in law. That's your point.
Yes, 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 my lords.
Mr. Lamba, what do you have to say?
My lords, I think, my lords, the notices which have been served to them are well within the rules and as per as section 282, my lords, because all these notices, admittedly, my lords, though I'll have to check the facts from the department also, whether they have served to the email account also. But all these notices were sent to his registered PAN, which is available online, my lords. My lords, these days, the entire account of an assessee is online, my lords. Straight away from filing of return till the refunds and all the communications. Because everything happens on his online PAN account. And my lords, admittedly, at para 11 of the writ, the petitioner says that it was available on its online portal at para 11, my lords.
Yes, that is my specific case, that it cannot be on the portal, but it has to come on the email ID.
What does Rule 127 say?
Yes, my lords.
My lords, that
Rule
portal
1.
is an electronic record, my lords. And 282 subsection 1C specifically says in the form of any electronic record.
Plus, that has been interpreted by Gujarat High Court as well, not challenged by the department. Let's Rule 127 we have quoted, minutes at page 10.
Page 10.
Yes, minutes of the petition.
Yes.
Every notice or other document communicated in electronic form by an income tax authority under the Act shall be deemed to be authenticated. In case of electronic mail or electronic mail message, hereinafter referred to as the email, if the name and office of such income tax authority, is printed on the email body, if the notice or other document is on the email body itself, is the printed on the attachment to the email, if the notice or other document is in the attachment, and email is issued of an electronic record, if the name and office of the income tax authority is displayed as a part of the electronic record, if the notice or other document is contained as text or remark in the electronic record itself, is printed on the attachment in the electronic record, if the notice or other document is in the attachment, and such electronic record is displayed on the designated website, the Principal Director General of Income Tax Systems or specify the of the for ensuring authenticity of the communication. Explanation: for the purpose of this rule, the explanation electronic mail and electronic mail message shall have the same meaning respectively assigned to them in explanation to section 66A of the Information Technology Act 2000. Electronic record shall have the same meaning as assigned to it in clause T of subsection 1 of section 2 of the Information Technology Act 2000. Now, this particular issue has been dealt with by the Gujarat High Court. That also we have quoted at page 17 minutes. That what would be the valid issue, valid service of notice that has been taken care of.
Gujarat High Court judgment has not dealt with the service of notice through electronic mode. It has dealt with the notice in the normal format.
Minutes in fact, recently, very recently, the this is from Delhi High Court. This recent order passed by Delhi High Court in the case of Dauji Abhushan Bhandar. This I could not mail to the Honorable Court because it came to my knowledge yesterday itself. This judgment is dated 10th of March 2022, and the Honorable Delhi High Court has taken note of Section 282, read with 127A, and quashed the notices.
Quashed the notices on what ground?
On the ground that the service of notice on the web portal is not a valid service.
Mr. Lamba, will you be able to seek instruction by tomorrow?
Malaj, it is very difficult to Malaj, seek instruction, Malaj, but by tomorrow, Malaj, let it be after vacation, Malaj, I'll file a detailed counter, Malaj.
Is there any time limit for concluding the proceedings under the
No, this is well within time. Well within time. Because the matter pertains to assessment year 2018-19, so it has to be March 2023. So it is well within time.
So in that case,
I will not argue on those issues.
Mr. Lamba, you get instruction and file counter affidavit. We will keep it on 6th, 7th, 8th of June.
Yes,
Malaj.
In the meantime, I'll furnish my compilation also.
Yes. When counsel for the petitioner contends that without effecting service of notice upon the petitioner SSC in terms of section 282 of the Income Tax Act 1961, read with rule 127 of the Income Tax Rules, the
127A merits.
127A of the Income Tax.
Yes, ma'am.
There is an error in your prayer question.
I'll rectify it, I'll rectify it.
Notice under section 148A(d) has been issued on 4th April 2022. (148A)(d) and 148 has been issued on 4th April 2022, which is not proper in the eye of law. Mr. Counsel for the Department, Mr. Rahul Lamba, respond is allowed time to seek instruction and, if necessary, file affidavit. Stop. The matter be listed on 8th June 2022.
Can I pray for only 3 days time for filing rejoinder if required, Mills? Only 3 days time.
June 2020.
14th June. Much obliged.
3 weeks to the department. 1 week thereafter.
Much obliged.
We just see who is appearing in hearing cases, whether they are ready or not.
For hearing, item
My
number
lord, I
35.
appeared in item number 35, my lord.
हाँ, क्या बोलिए मिस्टर प्रदीप कुमार?
Yes. In this case, my lord, the petitioner placed
नहीं,
was, my
we
lord.
are not. We are just trying to know as to who all are ready in the hearing cases. We will again take up these cases after few passover cases of admission are exhausted. You are ready as a petitioner's counsel in item 35, Mr. Pradeep Kumar?
Yes, my lord, I ready, my lord.
Respondent who will be appearing?
Respondent number 1, I appear on behalf of the Union of Indian Ministry of Home.
Okay. So you are the central government standing counsel. ASGI not appear.
SGI not appear.
Okay. How many respondents are there? Are there other councils also?
UPSC respondent number 2 है जयपुर रहमान.
Okay. And Mr. Mukhtar Khan and Nishu Sinha were the previous central government councils.
No sir, अब तो नहीं रहे.
एक मिनट. Respondent number 7 है private respondent. We will call it up again after admission cases. Yes, item 36 who is appearing.
Yes, Your Lordship, I am appearing, Your Lordship. Your Lordship, in this case, substitution petition was to be filed, Your Lordship. It has not been filed, Your Lordship. So, trying for further time to file substitution.
Sole petitioner has died.
Yes, Your Lordship.
His cause of action survives.
Yes.
What was the cause of action?
From OA case was filed, Your Lordship, for the promotion, Your Lordship. And for the Your Lordship.
Teachers say seniority.
Yes, Your Lordship.
What difference would it make if they are in the same batch now?
Your Lordship, it has to be argued by the senior counsel, Your Lordship.
Was also imposed when the OA was dismissed.
Yes, Your Lordship. 5,000.
You have already taken time on 5th January 22.
Yes, Your Lordship.
This writ petition has abated. You have not carried out the substitution.
Yes, Your Lordship.
And my lord, fresh number was also directed to file.
Binu Mukherjee, madam, you appear for whom?
My lord, Union of India for one.
For one.
I'm appearing on behalf of the state, Your Lordship.
There are no private respondents.
No, Your Lordship.
No, Your Lordship.
And you are asking yourself to be placed above two IS officers
Yes, sir.
in the merit list of 1995 members. Without the private respondents, how is your relief maintainable? Their seniority would get affected.
Your Lordship will make party if necessary, Your Lordship.
यहाँ रिट पिटिशन में अब थोड़ी पार्टी होगा, कैट में आप पार्टी बनाया ही नहीं है तो देख लीजिए. You seek instruction from the legal layer. Perhaps here the cost may be increased. 5,000 may go to 10-20,000 if we don't find any substance. इसको no application for substitution has been filed despite time taken on 5th January 2022 by Land Counsel for the petitioner. Please send your appearances. Stop. Land Counsel for the petitioner, Mr. Ram Prakash Mishra.
Ravi Prakash.
Ravi Prakash Mishra is for one more indulgence. You take instructions from the legal aids, whether they are serious or not, because there doesn't appear to be much substance. This is on 8th of June 2022. No further adjournment to be granted.
Right.
Last question.
Final hearing, item 37, WPS number 1601 of 2011. Mr. Mahua Pali for the petition.
Apply for adjournment, madam, on behalf of Mrs. Devenpal, senior advocate. After vacation, this case will.
Yes.
After vacation.
They are appearing on behalf of the railways. The name of Mr. Prashant Pallam may appear, Your Lordship.
Mr. Prashant Pallam would be ready today or not?
No, Your Lordship, the file has not been handed over to us yet. Let it be after vacation.
Mrs. Paul had taken an adjournment earlier to seek latest instruction, whether you are in touch with your client or not.
Yes, my lord. As per instruction of my senior, my lord, she said, my lord, this case may be taken after vacation, my lord. If possible, or if I do, my lord.
Likhiye. Mrs. Mahua Palit, Land Counsel for the petitioner, seeks an adjournment once again on the ground of learned senior counsel Mrs. M. Paul. Stop. You are, what's your good name?
For the railways, Your Lordship, Mr. Prashant Pallam, name of Mr. Prashant Pallam.
Since ASJI would be appearing for the respondent railways, a prayer for adjournment has been made on his behalf, as the file has not yet been handed over to him by the erstwhile counsels. Stop. Let the matter be listed on 8th June 2022. Stop. No further adjournment would be granted. Stop. Let the name of Mr. Prashant Pallav, learned ASJI, appear in the cause list in place of the erstwhile counsel for respondent.
Obliged.
Yes, now let's go back.
Possible cases, item number 12, LP number 341 of 2021. Mr. Rao for the petition.
Yes. May I, my lords?
Yes.
My lord, I have given your lordships directed me on 18th of April. I have given a compilation containing, my lords, all the relevant extracts only with an index and a chronology of the index, my lords. If your lordship will see the index from page number 1 to 88, out of, my lords, the LPA page number which is on the previous column, if your lordship will see the index.
the matter on the aforesaid date. Mr. Biswajit,
Yes, my lords.
there is one thing which you need to point out before you start.
My lords.
As you are aware of all the previous dates on which the case was taken up before us or the other bench, before this bench or the other bench, the last date's order reads as, in view of the nature of order dated 18th April 2022, let the matter be placed before the appropriate bench which has heard the matter on the aforesaid date.
Correct, lords.
Now, there is one difference. The bench is not the same which had heard your matter on the previous date. And this, because Brother Justice Roshan is not there for personal reasons, so therefore we are having a new constitution.
I appreciate this. may I explain to this on the court? I understand what my lord is saying. In fact,
replication of the same kind of argument in the same time that you have already devoted earlier in the.
I'll not take much time, my lords. As long as my lords, both of the honorable judges are agreeable to it, I'll not take much of the time. It is a very small, short and small submission. The substantial questions of law constitutionality that will be decided by my lord at the final stages. This order of 25th of April 2022, the honorable decided here. My lord, yes, the constitutionality will be decided the final hearing. The propositions, in fact, not the constitutionality, the propositions which I have. Yes. So the proposition.
Just a minute.
My lords.
Just a minute. Yes, Mr. Vishwajit does.
Yes, my lords. I think, my lord, if there is any problem, my lord, I can explain to the honorable court in what circumstances this particular order has come. Pursuant to my submission.
No, you need not labor on that. We
lords.
are going through the previous order sheets.
My lords, actually, what happened on that day? I
One
explained to
difficult.
the yes, on that day, my lords, on 25th, actually, I explained to the honorable court regarding two bench. One, your lordship's bench, because what was happening is that because it is an assigned matter of the lords, the DB1, and the honorable DB1 was not sitting on a regular basis, Lord, until 25th. That is the first time, Lord, when the honorable DB sat. Prior to that, this particular matter, Lord, came before two bench. The DB3, that is on 28th of March, when your lordship's bench was not functional. Post that page, Ballots, your lordships always took up that matter, but could not take up the finally ballots because of the fact that ballot this was a assigned bench of the DB1 ballots. And this particular factual submission made by us, by both of our council ballots before the Honorable DB1, the Honorable DB1 was agreeing, only said that because this bench is heard, one of the bench has heard this matter, that is the 18th bench, it meant to say it is DB2. It is not exactly the wording as it is appearing to be. That bench which heard, it is actually meant to say that it's a DB2 because it passed a direction, it heard the matter, and it passed the direction to fight the compilation. We are sending it to that bench. Only when I submitted to the honorable court that if tomorrow if there is a confusion happening regarding the assigned roster which is granted, LPA is of a DB1, but DB2 was not there. In that event, the court has recorded to this extent saying that we are leaving this matter for the DB2. It's not exactly to be because to avoid the confusion, pointedly on my submission, the honorable court has recorded this, saying that this is a matter beyond the roster. This is a matter to be listed before the DB2 because the DB2 has heard the matter. It is not to be seen that this is a matter to be listed on a particular date only.
We are not joining issues on whatever you say because you are party to the proceedings there also, here also.
My duty to vote. Yes.
You are privy to both. What we are confining ourselves to is the first three lines. In view of the nature of order dated 18th April 2022, that order was of DB2 in which myself with Justice Deepak Roshanjay were sitting. Now, which had heard the matter on the aforesaid date. So the bench was of a different constitution on that date. Maybe because of the order that we had asked for a convenience compilation, and maybe because of whatever was said by the parties before the DB1 on that day, an impression might have been generated that we had heard it on merits also to some extent. We do not join issues on that because that may also apply to the first order which was passed on 28th April also.
Ballots.
So, but the first three lines of this order actually makes our position a bit difficult because brother has not heard the matter on the previous date, 18th April.
That is why, Balot, I said that I'll not take much of the time to explain. I'll not take much of the time to explain to the Honorable Judge, Malot, the Honorable Justice Chaudhary. Malot, I won't take much of a time.
Please listen, brother is saying.
Yes, Malot.
As you are well aware, that this matter is a assigned matter to this bench. And whenever there is an assignment, it has to be within the four corners of the assigned order. So to my understanding, when it says that place before the appropriate bench which has heard the matter on the aforesaid date, on that day I was not here. I would have loved to hear you on this subject. And there is no, and we are really,
no running.
I could feel the concern of my senior brother judge also on this issue, that for some date you have been we have been not able to give hearing to you for one unavoidable reason or other. But the fact of the matter is that it will be better if this matter comes before the bench which had really heard that on that day, or some other order comes from the bench number one.
May I explain more of the legal principle on this? I understand what my Honorable Justice Chaudhary is suggesting, my lords. I fully appreciate, my lords, that my understanding of law, my lords, is this: that on 18th there is a assigned bench that was a DB2 containing two honorable judges, where the honorable justice, the honorable justice, my lords, Apresh Kumar Singh is the presiding judge, my lords. Now that is a routine order, my lords, where your lordships heard both of the honorable judges, that particular bench on that particular day heard that matter. It is not like a ballots, it's a binding precedence in the context of that 18th and then 25th. If lots will see in the entirety ballots. It is not something kind of a binding concept to the extent saying that the bench which meant in this second line of the 25th order only made that particular a particular combination on it. It may not mean that way. And the facts which I have put it before my lord as one of the counsel who argued on the basis of whose submissions this particular recording is done, and in the presence of my colleague, ballots from the respondent side, opposite party side ballots, I only say that your lordships will not be violating or deviating the principles, norms, or the law. If your lordship will hear today, in view of the second line of that particular order of 25th of April 2022, it's a judicial order. The 18th order is a judicial order. You also will appreciate one thing: the combination of the benches is always subject to the roster. Now the roster is complete today. Since the roster is complete, ballots, that particular direction, it is up to your lordships judicial conscience to read it the way your lordships will read it. But there is no precedent, there is no binding legal principle.
Mr. Biswajit, again, we would not like to join issues because the 18th April notice also speaks about the constitution of the bench. DB2 comprising Honorable Mr. Justice Apresh Kumar Singh and Honorable Mr. Justice Deepak Roshan. Let us leave it aside. Let us leave that aside. We just want to know whether there is any such imminent threat upon you today which is unavoidable because the sequence of dates of over the last, say, 1.5 months, when the matter has been taken up here or there, wherever, does not actually present, and Mr. Pati is also here, does not present a picture that you are facing such an imminent threat that if hearing is not accorded to you today by any bench, this bench or that bench, you would be made to suffer some kind of an irreversible or irreparable loss. If that is so, then there are two reasons. First of all, this bench is not the same bench which had heard on 18th April. The second one is Mr. RBI's counsel has entered appearance today for the first time. So, if both the reasons are persuasive enough, then we can keep it on any date just after the opening of vacation because Brother Justice Deepak Roshan would not be here in this week.
May I submit, Velots? As far as the pointed query of imminent threat, Velots, if this order of 28th of March can be read both ways. 28th of March order, Velots, says that the court is querying to the respondent number 3 only, not the respondent number 2 bank, RBI. It is querying a pointed query to the respondent number 3 saying that why that the interim order of 11th of November cannot be restored. And that is why, Balot, your lordship will hear on that pointed submissions. Regarding the threat, Balot, this particular order can be read differently. One, as long as the court is trying to bring about a status quo ante, it can be meant that Balot, there is a status quo, I may not have an imminent threat. This is one interpretation, Balot. Number 2 also, that there is a bank, if I will be left to the Balot, the benevolence of the bank then. But yes, till now, the bank has not acted in a coercive manner.
Bank has been benevolent enough, and Mr. Pati has been...
I leave it to your lordships. Balot.
My lord, may I submit, my lord?
Yes.
My lord, this would be... There is no notice of auction sale as on date, my lord, till today. Even if assuming, my lord, what my friend is saying, that there may be a possibility that I issue any notice, then in that case, since this is
I'm not saying.
Let me complete, please. Assuming, I have said assuming, I am not saying that you have said so. Even assuming if you make such some, if you assume that I will issue a notice in a day or two, then also, my lord, since this is the first attempt, in any case, I will have to give a clear 30 days notice. Now that will include a personal notice upon the borrower. I will have to exclude at least 3-4 days for the postage time. So in any case, if I give it even tomorrow, if I decide to issue the notice tomorrow, I will not be able to fix the date of sale before 17th of June in any case.
Well, this is not an issue. The precipitation,
as on date, there is no notice of auction
I'm only
sale.
answering your lordship's query that if there is an imminent threat, I'm only saying that yes, apparently there is no imminent threat in the sense that because they have not taken any action till now. But to the extent of Mr. Pati suggesting that they will be issuing ballots, to that precipitative actions ballots, I don't think ballots. This is something the court, the bank will change the position from 28th of March, responding to a query for posting the action for a putting of it to the previous date. Your property or a bank can go into that stage despite the fact that I am in a difficulty not to. Yes,
Mr. Vishnu, interim orders are not for the asking. You have lost before the writ court. Here, the appellate court would be first satisfied on your case for all the three ingredients, and then if it deems necessary, it would either restore any interim order passed earlier in whatever manner, or may pass a new an interim order in a new language or a fresh interim order operating from prospectively. But the first criteria for being for entertaining a plea for interim relief is that there should be an imminent threat. That we don't find from submissions of you also and the bank also.
I request, Lords, my humble submission, your Lordship may not kindly give any observation on that. I am only saying this much.
No, we have not yet entered into your matter. The last date, in fact, the order is innocuous enough, and you were yourself there. We had asked you to give compilation so that we can appreciate whatever you are arguing. But be that as it may, the order of 25th April is there. You can have it again because the court is closing from Friday onwards. You can have it on any day after its reopening. When
my Lord may kindly give that particular date. I have no problem, my Lord. Only problem is that, my Lord, this particular matter is actually it's something beyond any of our control. It has gone into a stage, I have not been able to complete my argument except on 20th of March, where I have argued for about an hour, where the court has already appreciated the prima facie merit of the matter and then has recorded that there. That is the reason, the court was even going to the extent of putting the status quo ante stage, That's something generally court doesn't do unless there is a overriding the legal grounds and justifications, and the three parameteria which your lordships have suggested. That is those such kind of a putting up the status quo ante to a previous date. It's a very rare these days in the courts. Only during the COVID time period, that kind of order was passed by the Supreme Court as well as all high courts, which I have given the compilation of here. So anyway, I leave it to your lordship's kind consideration to put up a particular date. Only my humble submission, this particular order 25th of March, should not come again in the way, because I only can assist as an officer that there is no precedent binding on this on the court. There is no binding on the court as far as that particular content of that order is concerned. Vis-a-vis 18th and 25th lords. That's my only humble submission. I leave it to your lordships because I'm always ready for argument and interim order and satisfy your lordships, notwithstanding what the 28th of March. I'll again satisfy the three parameteria. I'll again satisfy to my lords.
In view of the order dated 25th April 2022, the matter has been placed today. On the mention placed today before this bench, on being mentioned by learned counsel for the appellant. Stop.
Another humble submission, my lord, one small humble submission. In view of the difficulty, my lord, your lordship may kindly put up a date without giving any observation about the imminent threat and all. My only humble submission, my lords.
No, we are not going to say anything.
So much obliged. I'm so much.
Mr. Pandey Neeraj Rai has appeared today on behalf of the respondent RBI and has uh, appeared today on behalf of the RBI. Stop. Mr. Pandey Neeraj Rai has prayed for some time. And supply of documents or what, Mr. Neeraj Rai?
Milord, what happens by order of this Honorable Court of 28th of March, there was an advance service directed upon me, contemplating that I might appear. So they had informed that I usually appear for RBI. I'm to appear only on instructions. Not an empanelment. Milord, an advance copy was served. What I see is I've got the copy of the memorandum of appeal and 3 IAs, Milord. But the interlocutory application for stay is not there. One IA is for condonation of delay, another IA is for ignoring defects, and one more is for permission to file additional document. This permission to file additional document is something which should concern me, because I was.
I'll give the once again, but it is nothing to. Okay,
Yes, sir. Just.
It has already been given, Manoj.
Just. The IA which was being pressed today is not with me. I don't know what else they have filed which is not with me. So they must ensure with my office that everything is there.
Then counsel for the appellant, Mr. Vishwajit Das, submit that he would be supplying the meetings or part of which has not yet been served upon Mr. Pandey Neeraj Rai, appearing as counsel for the RBI.
I'll seek instructions on this interlocutory application seeking permission to file additional documents. At appellate stage, they want to introduce what may be termed as additional evidence.
Neeraj Rai also submits that he will be filing reply to interlocutory application.
Yes.
Number
2924/2022.
2924 of 2022.
I don't know, Milord, if my learned friend appearing for the bank has filed it or not.
There was a specific direction to file IA, reply to the IA for interim order. For that reason,
because Milord, this application, Milord, ideally speaking, this application has to be pressed by them firstly. If they are not pressing it, Milord, I have no occasion to seek any questions and file it.
When counsel for the appellant, Mr. Vishwajit Das, submits that the matter may come up on any date after reopening of summer vacation 2022. Mr. Das, whichever date you say.
Your Lordship may give me. My Lord may kindly give it on the second week of on a reopening week, my Lord. If Your Lordship can give me on the reopening week of June.
8th June 2022.
8th June, Your Lordship is okay with me. My Lord, in the meantime, may I draw Your Lordship's kind attention to the 28th of March 2022, where the continuation of 1 day has already been condoned. Delay has been condoned with the 1 day. So, therefore, my Lord, there is no reason why the IA number 2420/2022 for a continuation of delay may be, my Lord, retained in the records. My Lord, it should be directed to be disposed of.
Condonation? The delay was not operating at all these days because of the order of the Honorable Supreme Court.
1 day's delay in filing the latest petty appeal is condoned. That's a para number 5 of the order dated 28th of March 2022.
जहाँ लिखे Mr. Pandey Niraja reply to IN number 2924 of 2020. She missed it on 8th June.
The consideration of interim applications. That's maybe can be observed.
What?
That is for the consideration of the interim applications of stay, my lords. That's how the last all along we are actually
It may be heard finally, my lord. He is interested only in stay, my lord. It may be heard and disposed of on the same day.
Because 28th of March the order says so.
Mr. Biswajit, we are just trying to avoid saying something because of the constraints this bench is facing to entertain your prayer. Now we do not want to say more beyond what you have.
So much obliged, lords. But on
So
merit,
therefore-
Lord, I'm willing. I'm looking for that particular day,
In
lords.
fact, my lord, that part of the observation, my lord, which concerns me, that IA should be filed, the reply to the IA should be filed, that may also, my lord, be avoided for the time being. Because he has not pressed that IA.
That's a matter of merit. I've already argued.
That's a matter of merits. He has not pressed that IA. We will file it, my lord, if an instruction is received. But since this bench is not considering the matter on merits, therefore I am just suggesting.
Yes.
My lord, another concern. My lord, my small another concern. 25th of April 2022 order, that appropriate bench. I mean that, my lords, if it will come in impediment, my lord, on the next 8th of June, my lords, that's something which I don't know, my lords, because the composition is the prerogative of the Honorable Chief Justice, and the roster will operate accordingly. Now, does it really, my lord, impede on that day? That's something, my lords, is a concern for me.
Mr. Biswajit, we will cross the river bridge when it comes. Why should we comment upon that?
But my lord, despite the fact that I have persuaded the court on one occasion on 28th of March, my interim order still, I'm not being exhausted with that, lords. So much obliged.
Item 70, LPA number 769 of 2019, Mr. Devkant Rai for the appellant, Mr. Jain, thank you for the
Lord, I am appealing Lord in this case. Lord, on 26th of April 2020, on 26th of April 2020, Lord,
yes.
other side, Lord, served the copy of the affidavit, Lord, wherein they have annexed, Lord, order dated 18/12/2020, Lord, which has been passed, Lord, after passing of the honorable order passed by the honorable single judge. That order, Lord, I want to bring on record, Lord, and I want to bring some, Lord, amendments, Lord, to that effect, Lord. For that, I have filed an IA, Lord, that is 3907 of 2022.
That's a fresh cause of action.
No, my lord, it's a subsequent event, my lord, during the pendency itself. And we were aggrieved, my lord, by the observation itself, my lord, that the 3.45, my lord, acres of land, my lord, for which the learned honorable single judge your lordship has opined, that has been acquired. So we were only aggrieved by that only, my lord. That part we have preferred this.
Mr. Topo, you want to file a reply prayer for amendment? Or
filing a reply, my lords. I'll be filing a reply, my lords.
Appellant seeks to lay challenge to the order dated. What is the date of the order? 18 December 2020.
Yes.
My lord.
The next to C to number 3288 of 2022. No, 3907 of 2022. So, then counsel for this case will have 3 weeks time to file reply to this said matter be listed
May
after.
I pray, Your Lordship? May I pray, Your Lordship? We have filed an interlocutory application for the grant of status for Your Lordship.
No,
It is on board now.
there are fresh
The
developments.
situation, Your Lordship, is very tense, my lord. What they are doing, my lord, they have already demarcated the boundary, my lord, and they are bent upon, my lord, respondent number 5, Your Lordship, is bent upon to, my lord, make, my lord, constructions, Your Lordship. At least, my lord, till then, my lord, some protection, my lord. Otherwise, my lord, they are bent upon, Your Lordship. They have already, my lord, got this order, and thereafter, my lord,
Cancellation of Jamabandi is not irreversible action which cannot be corrected if we finally decide in your favor.
no,
So,
that is correct. That is correct. That is correct. But Your Lordship, what is Your Lordship? Our my lord,
immediately
situation is
after 3 weeks. Yes.
Item 24, WPT number 4027 of 2021. Mr. Manapuda for the petitioner. Mr. Ashok Kumar Yadav.
Decision application for a direction upon the
Mr. Poddar, we had passed an order in your case perhaps earlier on the basis of this 2021 SCC online judgment.
Yes,
that
yes,
the dues of the previous years, the years previous to the date on which the resolution plan was approved by NCLT, cannot be recovered.
yes, yes, yes.
Have you annexed that order?
That I have annexed. Yes, I have annexed Annexer 10 along with my supplementary affidavit, my lord, and I have also annexed the Supreme Court judgment, Annexer 9 in that supplementary affidavit, my lord. That was filed on 18/2/2022. Paragraph 7, 8, and 9 of your lordship's order clearly says that it is not recoverable on page 149 of 149 of this rejoinder, this supplementary affidavit.
Annexer 10.
Yes. Annexer 10. Annexer 10 starts from page 146, supplementary affidavit.
Now the position is again a very, what you call, a very subtle legal position that according to you, as per the judgment of the apex court and our judgment, no dues which were not part of the resolution plan
Yes, Lord.
outstanding on the date of approval of the resolution plan could be recovered from the petitioner.
Yes, Lord.
But what about those which were recovered before the resolution plan? This is the main issue here.
Yes, my lord. For that, my lord may kindly look into list of dates which I have stated in my rejoinder, my lord, page paragraph 7, page number 9 of my rejoinder. That will make the position very clear, my lord.
Because it was recovered after the resolution plan, my lords.
It was filed on 23/3/2022.
Outstanding claim was submitted करना होगा. सिक्योर क्रेडिटर ऑपरेशनल क्रेडिटर को वापस से पेमेंट करें, लेकिन जो स्टेट को नहीं किया वो बोले स्टेट का टैक्स हो चाहे कोई भी एक्साइज ड्यूटी हो, यदि रेजोल्यूशन प्रोफेशनल के पास वो क्लेम उस कट ऑफ डेट तक लॉज नहीं किया और अप्रूवल होने के पहले वो आया नहीं रेजोल्यूशन प्लान, तो स्टेट का 500 करोड़ का और 1 करोड़ का सब वही इसमें डिसाइड हुआ। इसका यहाँ पर एक पेंडिंग था कि हमको अब ड्यूज रिकवर नहीं कर सकते। यहाँ एक जजमेंट हुआ था बदलपुर का, नहीं रिकवर हो, वो जजमेंट इसमें चैलेंज था। सुप्रीम कोर्ट का भी हाँ ये वाला है। लिमिटेड इसको टेक ओवर किया। ये वाला जो 1/5/2020 का जजमेंट था ये वहाँ पर गया, वहाँ से उसी इसका दूसरे असेसमेंट ईयर का ये ड्यूज रिकवर करने के लिए कोशिश कर रहा था, जो पिटिशन पेंडिंग था। इसमें फिर हम लोग 10 जनवरी के ऑर्डर से कहे कि अब आप रिकवर नहीं कर। अब ये वाले केस जो प्रेजेंट है इसमें है कि रिकवरी कर लिया, उसका रिफंड These dues were recovered after the approval of the resolution plan.
Yes, my lord. List of date I have given in my rejoinder, page number 9, paragraph 7, my lord. Every
My lord,
the judgment operates on the interpretation of the amended provision of the IBC code from the date on which that provision has come into force.
Yes,
so it is not that if you have made recovery after the approval of the resolution plan, that is valid and is not covered by the ratio rendered by the Supreme Court.
Yes, my lord. Even my lord, there was a separate judgment by Honorable Mr. Deepak Roshan, which was impugned, my lords, in the Supreme Court, that the amendment which has been brought would be prospective in nature, but the Supreme Court has overruled it, saying that because it is only clarificatory, it would operate retrospectively. My lords, that is there, my lords. Only, my lords, I would indicate that in the counter affidavit we've stated that in the Supreme Court, the Honorable Supreme Court has only said that consequences would follow, but they've not specifically stated that refund would have to be made. There is no dispute about the factual position that the recovery was made after the resolution plan. That there is no dispute about that.
And no claim was lodged in respect of these dues before.
No.
So this would again be a unnecessary fight.
Manoj, if Manoj, it can be, Manoj, one way it can be disposed of, Manoj. No order has been passed on the refund application as on date. They submitted, we sent a show cause notice, they've replied. Manoj may dispose it off by saying that this may be considered in light of the Supreme Court judgment.
Then why did you take a stand in your counter affidavit? You should not have disclosed your mind.
Yes, that is my point also.
That predicament is there, my lords, but we've only stated that the Supreme Court has not specifically stated about refund.
No, you are I mean the Advocate General's office or your senior are the legal advisors of the state. If you are satisfied of the legal position as you appear to be, also in that case, taking a contrarian stand now,
My
would be something which the respondent state will ultimately have to eat itself.
Mr. Mitchell appears to be agreeing on principle but not on result.
Okay.
My lord,
So, if your authorities, if you have your deliberation with the authorities, which which convey a correct picture of the application of the Supreme Court judgment. In that case, there is no harm. Let them take a decision. Otherwise, they would invite a decision which would lead to a round of litigation again. We are not sure how it would ultimately be, which color it would take.
my lords, if I may suggest, my lords may keep it on the reopening week or the second week, my lords. I will speak along with my senior my lords to the officers and convey them the correct legal position regarding the Supreme Court judgment, my lords, and see, my lords, if they can take a decision prior to that date, my lords. My lords may indicate that prior to that date, a decision may be taken, my lords.
Refund application is pending.
My lords.
Yes, my lord, that is pending. But they have disclosed in their counter affidavit that since no order of refund was passed by Honorable Supreme Court, therefore I am not entitled to it.
Mr. Poddar, the central government has, it appears from the reports, given an impression that they are going to re-examine Section 124, the law on sedition.
Because in fact, it was stayed today by the Honorable Supreme Court, my lords. It has been kept in abeyance. It has been kept in abeyance.
And that was the question which in fact was concerning as to what would happen to criminal cases already filed under Section 1.
No new fresh cases, my lords, have been directed to be lodged.
Okay. So therefore, they can very well take a reconsidered view of the matter. Stand is taken, withdrawn, all this happens in course of the journey of a litigation. Which is the refund application annexure?
Sir, my lord, may kindly, yes, refund application is page 79 of the petition. Page 79 of the petition. Annexure 6, my lord.
Though a counter affidavit has been filed, more than one counter affidavit has been filed.
No, Lord, only one counter affidavit has been filed, and I have filed supplementary and rejoinder also.
Though a counter affidavit has been filed by respondent state. Respondent number 3, who is he? Sales officer. But learned counsel for the respondent state submits that the matter may be adjourned for 3 weeks so that the respondents may take a decision on the refund application pending before them in accordance with law. And the judgment rendered by and keeping into mind The judgment rendered by the Apex Court in Civil Appeal number 8129 of 2019, dated July 13th April 2021, in the case of Ghanshyam Mishra and Sons Private Limited through the authorized signatory versus Edelweiss Asset Reconstruction Company Limited through the director and others, and a batch of analogous matters, including the civil appeal number 7147-7150 of 2020, arising out of a judgment of this court in the case of the same petitioner?
Yes, my lord, same petitioner.
Same petitioner. Stop. As prayed for, list the case on. Ninth June would be good enough?
My lords.
9th June 2022.
Obliged.
Obliged.
Item 26, WPT number 985 of 2022, Mr. Nitin Kumar Prasadi for the petitioner, Mr. Rahul Sabu for the
October में last hearing. Yes, Mr. Kurmi.
May it please the Lordship. While in this case, mainly three issues are involved, my lord. One, that the impugned order at page 120, annexure 5.
Mr. Rahul Sabu is there, or you will be appearing, Mr. Jagdish?
I am appearing, my lord.
You are ready?
Yes, my lord.
Very good.
My lord,
Yes.
the short point involved in this case is that by impugned order dated 1st November 2021 at page 120, annexure 5, the input tax credit is denied without issuing a so-called notice to me. In their counter affidavit, the respondent accepts that they have not issued any so-called notice to me. Straight away, they have issued a DRC 01, and thereupon this order is passed. And thereupon, my lord, DRC 07 summary of the order is uploaded, and thereupon the garnishing proceeding is initiated. My lord, the order is at page 120. Kindly have it, my lord.
But the fact remains that you had replied to the summary of show cause notice.
No, my lord, I did not serve reply. DRC 01 was never served upon me. What was served upon me was ASMT 10. Upon scrutiny of return.
So it was only your part B.
Yes, part B of I filed ASMT 11. In reply of ASMT 10, I filed ASMT 11 my reply. Then, without considering that, they issued DRC 01A to me. And I filed reply to that also.
So that was part A.
Part A. And thereupon, without issuing so-called notice to me, they issued DRC 01 and 02, which was not served upon me. My twofold contention: one, that DRC 01 is not substitute of so-called notice. Your lordship have already held in the case of NKS, so there is no so-called notice at all. Straight away an order is passed.
NKS is still holding the field. It is not.
Yes, my lord, it's holding the field.
Not subject to any challenge.
To my knowledge, is not, my lord. Both the orders.
Very well.
So, my lord, without a so-called notice to me, then their counter they are accepting that they did not issue any so-called notice. Straight away they issued DRC 01. That too, that was not served upon me.
They are making a statement in their counter affidavit that you have replied to DRC 01.
No, my lord, it is not DRC 01A.
Somewhere.
What's to that?
Page number 19, my lord. Subpara F. of the counter affidavit.
Reply to the above form GST DRC 01A on 3rd April 21.
01A, my lord. 01A is at page, kindly see, my lord. 01A is at page
01A, that means the intimation.
Intimation, prior to show cause notice. And that intimation says, page 94, my lord.
Yes.
Page 94.
Yes.
It is if you don't comply, then a show cause notice will be issued to you. If you lordship, I would see from the bottom third para, you are hereby advised to pay the amount of tax as ascertained above, along with the amount of applicable interest in full by such and such date, failing which show cause notice will be issued under section 73 to 731. That thereupon, my lord, straight away DRC 01 is issued. That they have enclosed with the counter, my lord.
Yes.
And in the counter also they are saying page 26, my lord, saying they're accepting that show cause notice not issued. Kindly see, my lord, the counter
26
of the counter, my lord.
Yes, yes.
Para 2, my lord, second para. It is further humbly submitted, stated that the petitioner through the present petition as assailed the above order dated so and so only on the issue of not issuing the show cause notice under section 73 of the GST Act, though the same was already intimated. Kindly see, well, the same was already intimated to it through the form GST DRC 01. Moreover, the present case is related to specific contravention of section 4 of the GST Act, which stipulates that the petition of return, that is on 28/10/2019, the petitioner was required to file the return by 20/10/2019. Further, the petitioner is trying to mislead this honorable court by asserting that the return was filed by such and such date and no form GST DRC 01 was ever served on him. So they are accepting that accept GRC not served upon me. DRC. If you lordship can see the order.
So basically, order is at annexure.
My lord, order is page 120, my lord. It's a brief order. Just I will read it, my lord.
Short order. Yes.
Brief order, my lord. Just I will read it. Or he would lordship would say I will read the read portion only. The last table above that, the para above that, my lord. Last table and the bottom para above that. निर्गत सूचना के अनुपालन में करदे व्यक्ति की अधिकृत अधिवक्ता डी घोष दिनांक 1/6/2020 को उपस्थित हुए एवं उसके द्वारा अपना जवाब प्रस्तुत किया गया। करदे व्यक्ति द्वारा प्रस्तुत कागजात संतोषजनक एवं तर्कसंगत नहीं पाए जाने के कारण DRC 01 एंड 2 दिनांक 1/9/2021 को निर्गत किया गया। DRC 01 and 2 was issued. In their counter, they are accepting. They are saying that they had issued DRC. So they are accepting that so cause notice was not issued. So my permission is that neither DRC 01 was served upon me, nor DRC 2 was served upon me, nor the show cause notice. So without show cause notice, the impugn order could not. In Mahadev construction, Arcade Tata already held.
The order sheet of the case is on record.
I have not got it, my lord.
The entire order sheet. So that would also show that after whether DRC 01 and 02 was served or not. First, that would also show that whether after DRC 01 and 02 section 73 1 was served or not. And that would also show as to how many the defend itself or file its reply. Many dates were given to.
My lord, show cause was not issued. Counter is saying that. Counter itself is saying, the impugned order itself is saying, there was no show cause notice. Straight away DRC 01.
Impugned order, you see, impugned order at page 121 also says करदाता को नहीं कोई स्पष्टीकरण दाखिल किया गया।
On the contrary,
पर्याप्त समय देने के बावजूद उनके द्वारा
in the counter affidavit they are accepting that our submissions were skipped. If you lordship would kindly see, my lord.
पर्याप्त समय में more than one adjournment.
My lord, kindly see page 30 of the counter affidavit. Page 30 of counter affidavit, my lord. Page 30, para 16. That with regard to the statement made in para 9 of the writ petition, it is humbly submitted that the reply in form GS 24 would not be placed on file. I have called 3/2021. However, the same dated acknowledgement. My reply to ASFT 10 was filed in 11. That was not considered. The genesis of show cause notice under proceeding on 73 is from 61. If my reply is found to be unsatisfactory, on section 61, then only proceeding under section 73 can be launched. In this case, my reply is not at all considered, and they have launched 73. That way also, my lord, I would say they could not have resorted to 73 because under section 61 my reply was not considered, and they're accepting that. So unless my reply is found to be unsatisfactory, 73 proceeding cannot be launched. And in this case, 73 proceeding is launched without considering my reply and without a show cause notice. If you lordship would kindly see the compilation volume 2, my lord. Section 61. Compilation volume 2, my lord. Section 61, page 24.
Just a minute.
My comparison volume 2, my lord.
Just a minute. Mr. Kurmi, fresh assessment proceeding after remand would be permissible if whether the limitation is still operating.
No, my
Period
lord,
of
time
limitation
is there.
for
Time is
this.
there.
This relates to April
Yes, my
2018
lord.
to March 2019. So when is the time going to
My
expire?
lord, it is 3 years from the September 19, 2021, 22, my lord. Till September 22, my lord.
Okay. Mr. Jagdish,
My lord.
uh, do you have the complete order sheet of the proceedings with you?
No, my lord.
We have a different bench at 2:15, Mr. Kurmi, and
My lord.
it's already past quarter 1:40.
My lord.
So we will resume after that special bench is over.
No difficulty, my lord. No difficulty, my lord.
Very well.
Yeah.